are in the dishonor mode. They want to fight in the wrong way. We're trying to use the right way of, follow God's example when he did it to Pharaoh. He announced to him, gave him notice that he wanted his people to come out to keep a feast to him in the wilderness, and he gave him notice. Pharaoh's dishonor is what brought the curses and the plagues on him, and that's the example we need to follow. We don't need to attack these people. We just need to give them notice, and their own dishonor will bring the charges against them.
That it just came to me. That's what we're noticing snow with this self-executing contract.
That's right.
That's right.
Exactly. This is what we need to follow the example of.
Well, he's in dishonor now.
Right.
We just don't have anything to stand on as the third-party witness to prove it.
Right.
Right. Mm-hmm.
I have a
Doug,
minor...
I have something to share with regard to foreclosure. I just went through a sheriff's sale where I took a notice of defect that Cindy and Wade had done, and it basically stopped any buyer from the sale.
Terrific. Yes.
So they're still continuing with their eviction stuff. I don't know how long the time frame is for them to go to the, I've got keys for Cashapp. It's kind of fun. They get a little nervous when they come to the door. I'll offer you $500 for your $100,000 home. Doesn't seem very difficult to do the next, but anyway, I just wanted to share that. But it does work. That notice of defect does work in terms of stopping individual buyers at a foreclosure. And I'm happy to share that with the group if anybody would like a copy of that.
Sure. If are you already a member of the Freedom News Bank?
Oh, sure.
Okay, good. Just go ahead and post it. Add it as an attachment to an email message to freedomnewsbank@yahoogroups.com. Yeah, do that. Great. Thanks for sharing that.
I just have a minor question.
Can I ask another question along the lines?
Yeah, just speak up a little louder so we can hear you.
Okay. One other question with regard to that. Does anybody have any knowledge about forcible entry and detainer and how that process works with regard to the matrix, so to speak, and the banks proceeding in their process? Hello?
Well, I know that Cindy has got, I don't know if you're aware of Cindy.
Oh, of course. I talk to her all the time.
Yeah, I think they're paralleling that process, and they're evicting the bank.
Right.
Okay, so we just need to do it before they do it. And you can always find defects in their process, which holds things up. Meanwhile, you're going through with your process, making sure you cover all the bases so that yours will be perfected.
Right. And perfection means that you have 30 days.
You give them proper notice and have it documented, yeah.
But something to be perfected, does that not mean that it takes 30 days after you record it and make it public? And then it becomes law? Is that what that means?
Not necessarily, no. It just means following the due process procedures, whatever they are for that area in that state.
I just wanted to ask on the copyright, did we change from the standard one to the one that is self-executing? I thought it just said in the event of. Or is that what we want to use from now on? The copyright with the self-executing contract.
No, I think I have both versions out there.
Right, but on tonight's call I heard that that might be the standard one to use, but in the files it says underneath it, it's got a little caption, used in the event of. And because I know what happened, Lewis asked the gentleman from Florida if it had the self-executing contract, the copyright.
Yeah, mine says, it's version 11, dated May 30th. It says my version was self-executing contract.
And that's the one we want to use now.
That's the one I've been using.
Okay. See, mine's
a little bit different, but it's similar.
Yeah, Lewis has got his own version of that, and
is yours on the board too, in the files?
It's not, but I can put it up there.
Just to compare.
Lewis, you have rights now to add stuff.
Okay. I have mine highlighted so that you can see what to change, and I can put it up there so you can compare them. But they're really pretty similar.
Okay. Yeah, I filed mine before this self-executing came along, so I need to update mine.
Mm-hmm.
Well, I think what we want to do in all of our notices of acceptance of your offer to contract, I think we need to have, and that's what I'm working on, and I was finishing it today, we need to have the part in there where we're putting them into an agreement. We're accepting their offer, and these are my terms and conditions, and you don't let them off the hook. You let them have the opportunity to withdraw their offer within 3 days, 72 hours. Otherwise, the other terms and conditions are in effect and ratified by them. Okay? So you want to get these people into contract, because that's how they get us. They get us with unilateral contracts. So we need to do the same thing.
So when we go to a bank and we open up an account and we want it marked private and their employees don't know what the heck we're talking about, and we get these non-responses, we can do this contract with them. If they haven't answered us in 3 days on marking it private, then...
Right, and whatever terms and conditions you want that they need to perform.
So if it's in there as a term and condition and they don't answer...
Then you give them a $500 fine or whatever.
Okay. I mean, I'm still not totally aware why it's that important to have it marked private. So it's not like I feel it's a battle, but I understand that I have a right to ask for that.
Well, the reason to mark it private is so that no one can know what's in your account.
And what I get from the bank is that doesn't happen anyway.
Well, that's what they want to tell you, but just watch when the IRS shows up and say, you got an account in this person's name? How much money's in there?
Actually, they send quarterly reports every quarter or every month, depending on what type of bank and where you're at, on every transaction, on every account.
To the IRS?
To the IRS.
Yeah, but if the account's marked private, they can't do that.
Correct.
Well,
that's what I'm saying. If you don't, that's why it's important to get it that way. Because your stuff is going up in a computerized format report every month. Every creditor every debtor that you've paid a check to, every check you've received, who the payee was, who you received the money from, that's all sent up electronically every month on every account in the country.
I believe you should never keep money in the bank, period. I keep it buried in the ground with a compass and a 200-foot tape measure.
Well, don't leave money there if you want to use an account to, transact business. But you're right, you should never have money left in the bank.
I never do, no. Just enough to cash my check.
That's it.
Yeah, and if they start garnishing, what you need to do is get them into a self-executing contract, too. You give them a notice of offer to accept their contract.
Well, the account should be registered on a UCC-1 by account number.
Mm-hmm.
You can do a quiet title on the account and, of course, serve the bank branch manager with your UCC-1, your copyright, and your quiet title, and then send a copy certified to the main bank headquarters. And some people say send that along every quarter.
Now, when you're talking about a quiet title, what is that on? I just see it referred to as real estate, but apparently not.
Well, I guess I should post some stuff up there or send it down to Doug, let him do it.
Yeah.
It's like a copyright, but the quiet title is a way of claiming ownership of something. It looks a lot like the copyright. You fill in what you're claiming ownership of. There's a $500,000 fine for violating your quiet title. Record it with the courthouse. You advertise it for 30 days. But we're going to do our kids. Next week I've got my quiet titles on my kids going out. So if DSS comes knocking on the door, $500,000 fine for messing with the quiet title on my kids, and then I can emancipate them when they get to be 18.
I have some information on this. What it means is like the title is noisy if several people are making a claim on it, the bank or different whoever. When you file a quiet title, it quiets it down and it states who really has rights to that.
Who has the superior claim?
That's what it means by quieting the title. It makes it less noisy. It clarifies who has the rights to it.
Okay, well, all this prompted one more question. This week in our messages, I was all set to go and close the one account I have. It's just the day I was going to do it. And then somebody else brought it up, and Lewis asked them to hold on, you're still getting the paperwork together. And the implication was that the letter we want to send to the the bank should go at the time we close the checking account. Is that correct?
No, it can go either when you close it or any time after you close it.
Okay, good. All right. I thought, again, I'd missed something, and okay. But that letter is important. When do you think we would have that?
As soon as I get the contract against snow finished.
Okay, that's the first.
I don't want to turn anything loose until I get that ready to give to everybody.
Okay, understood.
This is Harry again about the closed account checks.
Mm-hmm.
Yeah, whenever we set up, let's say it's a new account and you've already established all your paperwork with another account. So that means you're going to have to reestablish or send the information of the new account into the set up accounts already as far as the Secretary of State and the Treasury.
You're saying you set up a brand new account just so you can close it?
What I'm saying is I already filed my UCC with the national filing, and I already sent my information off to the Treasury.
Mm-hmm.
So whenever I start off this new, let's say I'll have to put up a different account for the closed account checks. So that means this new account will have to be entered, or this evidence or of the closed account will have to be put into the other filings?
You can either do that, or you can do a separate filing just for this.
Oh, I see. It would be like amended filing, or just something?
Well, you can do it as an amended filing, but the instructions that I'm setting up, it would be a totally separate UCC filing.
Oh, okay. So we can just kind of leave everything like it is.
Uh-huh.
Oh, good. Very good. Thanks.
Okay. My copyright pattern is now up in folder 2.
Great, thanks.
Okay.
I have 2 to look at.
Mm-hmm. And as soon as I get time to make some instructions to go with the administrative procedure, I'll make a folder and put that up there. Try to get that up tomorrow.
Oh, great. Yep. See it there. Fine. Is Penny on the line? I don't know if Penny's had a chance to call in yet. She's maybe still on her conference call or whatever. We've been able to do a lot of equity contracts recently, and we're in the process of sending those to Penny. So Karen's helping me with that, and she's been really great at putting it together, and she's helping Penny now to do some administrative things and some notices that go back to everybody. So we're actually, Karen's calling people and emailing them, asking for any additional information that they might have left out. So,
we better get those into.
Yeah, go ahead and at least get the information to us. If you don't have the money now, that's fine. We'll just be able to get the information typed up and ready. So when you want to go, then, and when Penny says to go, you just get the $200 to us or whatever.
Money. There is no money.
Yes, right.
Is that now? That's $200 on each loan.
I think it's $200 that Tim is requiring for each loan, for each different, and then $100 I think for actually every other loan that's for that same lender.
Well, but actually, part of it is for the CD he puts out that is about banking and fraud.
Yeah, that's another $100 that you do with their website.
Right.
Yes. Yep.
Right, yeah.
Okay, but on this particular piece of property, on this foreclosure, I have 3 different loans because I've refinanced.
Right. I think it's only...
Isn't it based on institution?
I think it's based on institution, yeah.
The way Penny described it to me when I talked to her about it was, if you've refinanced 3 times with the same mortgage company, that's a single $200 contract fee.
Right.
For all three of them.
I'm the only common in.
That's right. That's actually right. Yeah.
Okay.
Yeah, but if it was 3 times with 3 different institutions, and that's 3 times 200.
Even on the same, let's say the same property?
Yeah.
Oh, okay.
Yeah, it doesn't matter what the property is. It's whether or not it's the same banking institution. It's how many contracts do they have to create with the bank's name on it.
Mm-hmm.
I think that's one of the problems they've run into with rollover in terms of where the equity is with that. And so that's what they're considering how that's going to work. And it's my understanding of it. I mean, I got in this in the beginning.
Mm-hmm.
Penny knows more about it, obviously.
Yeah, and I don't think she has any update from Larry about the lady Joanne who is going to.
Just the recent posting, I think that was the 13th or something.
Yeah.
Plan B.
Plan B, right.
Plan B is very interesting.
Very interesting.
Mm-hmm.
Need at least 3 cups of coffee.
Well, originally they had another woman that was going to maybe fund some of this stuff, and no one has heard much about that.
Mm-hmm.
So they posted up a buyer Plan B program, and it's up on their site.
Yeah.
Well,
No.
Doug,
Yes.
is Harry again?
Yes, Harry.
I did mine back in February with Penny.
Okay.
And I'm probably pretty high up on the totem pole as far as they going by numerical or whatever.
Yeah.
And as soon as I get some kind of notice or results, I'll let y'all know.
Sure. Yeah, I don't think she's submitted anything yet because you're going to get a contract, a non-disclosure form to sign.
Okay.
First, then you'll actually get a copy of that contract once they have taken care of the processing.
Yeah.
And then you sign it and send it to the institution.
Oh, she's already sent me all the preliminary stuff like the amortization or the amount of money I should receive.
Yeah, that's what we're sending back to people too, right?
Okay.
And it's amazing. Some people are getting $1 million back.
Wow.
Yeah. Are they proceeding with that sort of thing, with accepting more contracts at this point?
With the understanding that it might be months, 2 or 3 months. It could be that long, or it could be 2 weeks if this lady wants to go ahead and has her IMF connections. And it's really hard to tell you. We just can't give you a date.
So, Doug, is it at all possible? I put mine in rather early, and in this wait period, the same institution, because it's a credit card, there have been additions. Can I add on, or is that going to be too complicated? You've already done worksheet and it's off, or...
Well, my understanding of that, Becky, can I...
Sure, yeah.
Let's talk to Penny about that.
Good.
Is that what they're going to do with people who filed really early, and I've been one of those who actually sent it off to the bank, is that they will add something to that to calculate the difference in the time you file. And they've got some additional things you can, like a letter,
right,
addendum essentially, to that, to bring it up to date for whatever your circumstances are.
Okay, I kind of got that. It was a little hard to hear. Would I send that to you, Doug?
Yes.
It's going to be very simple, and it's just...
Right. You would just... Yeah, whenever you want to send that, we'll just keep it in the file here and then add it at the appropriate time.
Great.
Yep.
Now, Doug, being I already did mine and I'm waiting for money, I'm not even going to proceed further, but I have about 6 or 7 mortgages.
Oh.
And I was going to say that I'll just go ahead and file them with you, shouldn't I?
Oh, yeah, that'd be fine. Yep.
Okay.
Yep. I guess that covers everything I had on my list. Does anybody else need anything to announce or?
I do have a question. I got a letter from a credit card thing, and I quit paying about the time I quit paying my mortgage. And I haven't done any process on it, but apparently they've written it off. They were low amount, like $200, but it's up to like $1,000. And so I get these letters saying that they're willing. Oh, they said that I couldn't write to them. It was only available by calling them, and they would take half the amount, and so whatever was discharged or written off would count as income to me. But I don't know if I even.
Don't call them. They're trying to recontract you.
No, do not call.
Right.
Okay, after 180 days, they have to write it off. That's law.
Okay.
Okay, so they have written it off. Your debt is gone. Sometimes they'll sell it to a third-party debt collector.
That's what I think they did.
Okay, but it doesn't matter when they third-party fire them. Do not talk to them on the phone. Do not call them. Do not recontract the debt. Okay, that's
it. 180 days inclusive of any bankruptcy filings, or does that stop that 180-day process?
Well, a bankruptcy filing is something totally different.
Well, if you file at 13 or something, does that stop that 180-day process for them?
No, the 180 days deals with a credit agency and how long they can keep an uncollectible debt on their books as good debt. It's simply a GAAP issue, generally accepted accounting principles.
Mm-hmm.
Okay, bankruptcy is a totally different issue.
Well, it affects it when you file one.
I'm sorry, say again?
I think it affects it if you file a 13. It affects that time period, whether they can stop it or review the process.
Yeah, but
I don't know the answer to that. I'm just asking.
Yeah, I'm not trying to deal with somebody who's in bankruptcy. She's got a case where they have written it off,
Okay.
and she needs to let that sleeping dog lie.
So you're saying whenever you fire the attorney or the debt collector's third party or whatever, you don't do anything unless somebody contacts you?
Well, you wouldn't even fire unless somebody contacted you.
Yeah, right. But what I'm saying is after you fire these people, don't do anything unless somebody else contacts you, right?
That's right.
That's right. Right.
With a credit card debt like that, after 180 days, they've written it off.
Right. It's been about a year since all my stuff, and I'm just getting some involvement with the debt collectors.
Fire them. They'll make about 3 or 4 attempts, and they should go away.
Okay.
Mm-hmm.
Hey, is that 180 days from when you stopped making your payments, or from when you last spoke with them and, per se, contracted with them? Where does that 180 days start and stop? Anybody?
I would think it would go once it went to a debt collector.
I think it's the last payment.
Yeah, it starts at your last payment.
Mm-hmm.
That's why they try so hard to make you make that payment on the phone, because it extends their statute of limitations, so to speak.
Oh, okay.
Speaking from a collector. This is Dan from Alabama.
One of the easiest things to do on the phone is if they call you, just say, I don't do anything over the phone. Please contact me in writing, and thank you for your call. Hang up. You have to do it in writing.
Well, Rice has some good comebacks on the phone. He just fires them, basically. You must be I don't know you. I haven't contracted with you, and you must be a third-party debt collector. You're fired if you think you're representing me.
Oh, here's it.
And it's amazing. These people know what you're talking about.
Yeah.
They really do.
Yeah.
I'm helping my partner. He's got a company, and one of his clients didn't want to pay the bill, so they had a lawyer send him a letter that, we're reviewing this for breach of contract. We may sue you. We'll let you know. And he wrote a letter 6 weeks ago, said, you're fired. And get out of my private commercial affairs. Man, he has not heard from that lawyer. I'm sure that lawyer got some money to get involved in that case. He's gone.
Yeah.
So it's not only debt collectors. These lawyers know what this is about.
Yeah.
Now, doesn't matter. Excuse me. It doesn't matter if they're trying to get you into arbitration. These third-party people.
Doesn't matter what they're trying to do. Fire them.
Yeah.
Okay. All right.
Yeah. The
Attorney firing letter up in the attorney contract folder.
Mm-hmm.
Use
Oh,
it.
yes.
Mm-hmm.
Oh, knowing that everything you say can and will be used against you. My daughter has had an accident, and she's fighting with where she was working for paying for it. So a hospital was calling to collect, and they called and asked me, well, is she still at box so-and-so? And I said, oh, no, she outgrew that a long time ago. And they said, well, who am I speaking to? And I said, me. And she just laughed and said, okay, thanks.
One of the things I've talked to a couple people with mortgage issues, one of the things they send out now is just an innocent-looking little form letter that says, you know, we need to update our information. Please fill in your name, address, telephone number.
Right.
And don't do it. You're recontracting.
Yeah.
Right.
Yeah, when they offer you these deals, 50% off of the debt, they're just recontracting with you to admit that you have a debt, and then they'll go after everything.
You know, that happens on the internet too. Like with Countrywide, for example, they'll ask you to fill out some information. It's almost like signing the contract.
Yeah,
That's exactly who I'm talking about.
Yeah.
Right, exactly. And so don't do it.
Actually, no. What you need to do is put the overlay on it. You know, accepted as truth, return for settlement and closure. That's it. Never ignore mail.
Yeah, because that isn't right.
Email per se as well.
What'd you say?
Email as well.
I don't know. Louis, you got any thoughts on email?
Well, since email is a non-verifiable medium
And private.
and it's private, I don't think so.
Okay, that would be my thought.
Because they have no way of proving that they sent you the email, other than they can say, well, see, we dumped it into the server, but that doesn't mean that the address that they sent it to ever received it, and it doesn't mean that it's the correct address for you. So, no, I would completely ignore any emails.
Okay, I agree.
That's junk mail. Put it in the bed bucket.
But if you get something in mail delivered to your house, your business, and it's somebody making a claim, do not ignore it.
Right.
Oh, right. Okay.
Right.
I wanted a clarification. You said someone making a claim, because I ignore plenty of junk mail.
Oh, yeah, if it's just junk mail.
Okay.
I'm talking about if it's your mortgage company, your credit card
Right.
company,
Of
you know,
course. Yeah.
the government, city,
Yeah.
state, local,
Phone company, whoever.
Yeah.
whoever.
I have a
Not
question
not
about
identify as
acceptance.
junk mail.
All right, question. I have a question about acceptance for value. If you get a letter and a document to sign something, which one of them do you accept the value in return for?
Everything.
Everything? Both of them?
If you get a letter,
Anything. Everything.
do not keep anything.
Well, I got this letter from the Keys for Cash people, you know, and they didn't understand it. They sent me another one. It sounds like you want to do this. So they sent me the contract back. It's kind of fun. So I thought, which of those do I accept for value in return for settlement?
Well, but I mean, did you have business going with them on anyway?
No, these are people who, you know, I went to the foreclosure and did a most defect, and now the servicing agent for Countrywide is trying to evict me, but, you know, so they hire a local real estate agency to come and offer a certain amount of cash for your keys down in certain days, and but you can accept that for value and return it for value.
Yes. That's something that's related to business you are potentially involved in. You can't ignore that.
And also I sent negative averment to the company if they had no claim on it.
Right. You always want to place the burden of proof on them. You don't want to make any statements, positive statements yourself, because then you're testifying.
Exactly.
You always want to use a negative averment style of affidavit.
When they keep sending you letters, do you have to keep responding to them?
Yes.
Yep.
The one you keep, recontract.
Yep. That means you've accepted it.
You mentioned a negative averment statement you guys had up on the files. Where is that located?
Oh, I've got several up there.
Yeah, there's 3 or 4 of them in different folders.
Mm-hmm.
Where would I look just offhand?
I think loan verification's got one. Attorney contract, I think, has got one.
Yeah, attorney contract, I know has one.
Mm-hmm.
The credit card companies, you send a bond in, they continue to send you your monthly bill. you send them another copy of the bond, and they continue to send you a bill.
Why would you send them another copy of the bond?
Send them another copy?
Why would you?
Why wouldn't you?
Because I was told send them a copy of what you sent them the first time.
Oh, okay. You're sending them a copy of the original. I thought you said you were sending them another bond. I'm sorry.
No. He said copy.
Okay.
Send them a copy of what you sent them. And that should be the end of it, shouldn't it?
Yeah. Just make sure you stamp that new statement accepted for value, return for closure.
Yeah.
I did.
Okay.
You
Well, you have to do it 3 times.
Oh, you have to do it 3 times.
It takes